Right, so we're still deliberating on the E-Levy, just as the minority has taken it to the apex court. They did this on the 30th of March, filing their case there. And as you heard, one of their members talking about what he anticipates, that is what they see. But we'll leave it to the courts as they slug it out there. But joining the conversation to help us break down the matters into bite-sized pieces, we have Bobby Banson, a lawyer and a law lecturer at the Ghana School of Law. Bobby, a very good morning to you.
Good morning, sir.
This morning, dear Charlie, you make me feel like...
You introduced me as a law lecturer at the Ghana School of Law.
Oh, so you're returning the favor, right?
This Charlie, something blowing my cover.
Are you? But we're grateful that you've taken the time to join us this morning. Even before we get into the court issue proper, you followed the Abdullahi versus the Attorney General, the state issue, and the court's directive when it comes to what constitutes a quorum on specific instances. Let's take away what it said about deputy speakers voting and all of that. That doesn't come into the picture here. When you look at it, upon a true reflection of Article 1041 of the Constitution, what would be your understanding of what the court in that earlier ruling said?
Well, I believe that what the court said would not necessarily be in contention. They were very clear that the quorum for voting is not the same as the quorum for conducting business. They have said that when it comes to one of them, I'm careful because I would not want to be seen to be prejudicing the outcome of the suit that has been filed by the minority. The words that they used lent to no ambiguity or vagueness. Were very clear that as far as they are concerned, when they interpret the provisions that were brought before them, the quorum for conducting business is not the same as the quorum for voting. And they explained the instances for both, where the deputy speaker exercising his constitutional rights or mandate on behalf of his people is entitled to vote on issues that have been debated already, but may not be entitled to participate in the business, like the debating and what have you. And so I believe that if what the minority says happened in Parliament, they think that it contradicts what the Supreme Court had said, they have clearly exercised their right to go back to the Supreme Court for what I would say clarification and then further application of their supposed interpretation to the facts that happened in Parliament on Tuesday, I believe.
And I know you're walking a fine line, trying to be cautious here, because especially as the matter is in court, you don't want to appear to be leaning towards this or that end. But did you follow proceedings in Parliament on the day when the E-Levy was passed? Did you see what happened?
Yes, we were following on social because at the same time we were watching and celebrating Ghana's football match. But then, I managed to follow bits and pieces as it developed, as the story developed.
What did you make of the proceedings? The Right Honourable Speaker saying that, well, the motion could go ahead, the walkout, the subsequent walkout, and all the matters arising. I mean, the picture is that some have claimed that, look, you were walking out, but in the process of walking out, the motion was tabled and we voted. That, when you put that side by side with, I believe, what Article 1091 of the Constitution says about those in the chamber who are present and voting, how do you reconcile them? Because the Constitution says in 1091 that these people must be present and voting. The majority side has said, no, in this instance, we voted with a voice vote, which counts as a vote, and that is also being disputed. But you guys had not left, not all of you had left the chamber at the time. And so those of you who were left, technically, added to our numbers, though they were not voting. What is your understanding of that?
I believe you were referring to 1041.
So there's 1041, and there's also 1091, which comes into the picture when it comes to those who are participating in the process. In other words, they must be present
Of the standing
and
orders,
voting.
or
That is the standing orders. 1091.
Okay, standing orders. Yes.
So 1041 of the Constitution, 1091 of the standing orders.
You know, for me, it becomes a factual issue. And when I was discussing it with some of the colleagues when the suit was filed, my colleagues, I was hoping that the Supreme Court may, even if it wills, call evidence to confirm the number of persons who were present at that time. So that, because that is the contention. Were they present? Were they walking out? Should they be considered as in the process of walking out once they were physically within the chamber and were not outside the doors, whether they will be considered as being present, whether or not the fact that they have demonstrated their intention not to participate, whether they should not be considered as present, or it's about physical presence or mental presence. I mean, using it, the word loosely, the mental presence, I mean. So it becomes another angle where the Supreme Court may decide to interpret, because the Constitution and the standing orders only said those who are present and entitled to vote. So if the majority, and I believe that assertion was confirmed by the Speaker in his analysis, think that, okay, you said you will not participate, you were walking out, but at the time that we tabled the motion, we did the vote, some of your members had not yet left the chamber, then, you know, there could be, it becomes an issue for factual determination. I believe that as the matters were developing, there were arguments that, okay, the numbers that the clerk of parliament recorded as being present are not entirely true, or those that were recorded as being absent are not entirely true. So that those become matters for factual determination to aid the interpretation of those constitutional provisions and perhaps the provisions of the standing orders.
So in this instance, it is clear that we have a case on our hands which could bring us to another determination from the Apex Court. And do you feel that could also give clarity to maybe some of what the Apex Court itself told us in the Justice Abdullahi case? Do you feel that this matter cropping up at this time could lead to further clarity from the Apex Court, or maybe even a shifting, no matter how minuscule or small it is, from its earlier position? Because now the Apex Court itself has said that, stated categorically, if you want quorum for some of these matters, you need 138, one half of Parliament. If it says anything different, it might mean that it may have shifted a bit from its earlier position. Would that necessarily be the case?
Well, the Supreme Court has confirmed over the period that they have the jurisdiction to clarify previous decisions that they have made. If in putting into practice that decision, there tend to be practical difficulties or ambiguities. So I believe that this will be a perfect situation where the invocation of their jurisdiction by the present action may result in them clarifying how to put in practice some of the things they have said. And I will not be surprised if they go back to the Justice Abdullahi decision and then clarify some of the things they have said. I do not think that they will shift the essence or the ratio or how they interpreted the provisions in the Justice Abdullahi case with the present suit filed by some members of the minority. But I think that if they deem it, they have always said that they have the jurisdiction to clarify some of the things they had said in earlier cases. And so they would clothe themselves with that jurisdiction and then bring clarity to the subject, how the things they had said in Justice Abdullahi could be operationalized in the day-to-day running affairs of Parliament. You know, it will lead to the counter-argument that the Supreme Court seems to be engaging in, or to be interested in the proceedings in Parliament and gradually setting out the rules of procedure in Parliament.
Would that be a problem? Would that in itself be a problem?
I don't think that on the face of it that would be a problem, because the Constitution says that Parliament would pass standing orders to regulate proceedings in Parliament. But if they have passed standing orders that have become the subject of interpretation, because the standing orders seek their source from the Constitution. So there will have to be constitutional interpretation, which is the reserve of the Supreme Court, which will have an effect on some of the provisions of the standing orders.
Right.
I think that the Supreme Court will not be, as has been argued, be rewriting the rules of Parliament and to regulate its procedure, but may be interpreting it and then giving clarity as to how what they have interpreted should be enforced. If there was no ambiguity, we would not have this situation where the minority would have gone to court. So the same decision by the Supreme Court, the majority is interpreting and applying it differently. The minority seems to be interpreting and applying differently. So we go back to the people who gave that decision and tell them to clarify what they meant.
Right. I'm not asking you to deliver a verdict, but prima facie, on the face of what we've seen, and I would have us get a bit into the petition, put together by Minority Leader Haruna Idrisu and other members from the Minority Caucus, Mahama Yariga and Okujeto Ablakwa. On the face of it, do they have a case? On the back of what Justice Abdullahi versus the Attorney General or the state revealed, do they have a case?
Of course they have a case. We are talking about two very senior legal practitioners. I mean, Dr. Ayine and Mahama Idrisu. They will not go to the Supreme Court on cases that are frivolous or they do not think that are worthy of interpretation. If you read the reliefs they are seeking from the Supreme Court would have to do some work to either clarify what they had said or interpret what happened in Parliament. They are asking for a bail or the proceedings that led to the passage of a very important bill to be declared a nullity. I believe that they have a case, and the Supreme Court would entertain the action, look into the facts, apply the law, and come up with a decision that they deem just.
So do you feel it is apt then, and I ask this, of course, political talk, but when the Deputy Majority Leader, Alexander Afenyo-Markin, says this case they're taking to the Supreme Court is dead on arrival, basically nothing in there?
Well, it's like you said, it's political talk. If it is dead on arrival, the Supreme Court the case would be determined as such. Whatever it is, there would be a decision. There are provisions in our law that allows cases that the opponents think are dead on arrival to bring an application to have same struck out on the fact that they discloses no cause of action or they think that the action is frivolous. If the deputy majority leader is of that strong opinion, I believe he can also exercise his right to bring an application to have the matter dismissed as such. But I doubt that would be entertained. I do not think that it's a trivial issue that should be taken on the face of it. Our democracy is developing. Our judiciary is there, has always been there to guide us through this process. And so if a Ghanaian citizen or no mean persons like Dr. Ayine and Mahama Idrisu and Samuel Okujeto decide to go to the Supreme Court to have an interpretation of of proceedings in Parliament and just oppose it to whether it is constitutional or not, I do not think that we should trivialize it. Like you said, maybe it's a political talk.
Right. So let's get into the content of this entire statement or this petition, the reliefs that are being sought. So, for example, a declaration that on the authority of the Supreme Court case of Justice Abdullahi versus the Attorney General, dated the 9th of March 2022, the constitutional quorum for decision-making and voting in Parliament within the meaning and intent of Article 1041 of the 1992 Constitution is 138 members and not 136 as the NDC evinces took place on the day when the E-Levy was passed. A declaration that in accordance with, again, Article 1041 of the 1992 Constitution and on the back of the Justice Abdullahi versus the Attorney General case, when the Right Honourable Speaker of Parliament put the question for the second reading of the Electronic Transfer Bill 2021, Parliament lacked the required quorum. Then there's also the point, a further declaration that by reason of relief B, the purported vote on the motion for the second reading of the E-Levy Bill 2021 by the 136 members of Parliament was in contravention of Article 1041 and therefore null and void and of no effect whatsoever. It goes on and on. Do you feel, in this instance, I mean, just school us, is it possible for the court to grant some of the reliefs and take out some of the reliefs? In this instance, I pose the question because all of it is hinged on 1041. And any decision stating that the quorum number is this, clarifying what they did when it comes to the Justice Abdullahi case would mean that a confirmation of the 138. Is there any room, basically, to squeeze out of this? Because it appears it's either going to be that they stick to what they said before, or they are now, in giving further clarity, they are going to seem to be moving away from what they said. I don't know whether you get what I mean here.
Yes, I think the petition filed, the action filed by the minority is premised on their understanding of the ratio in the Justice Abdullahi case. And so you notice that the relief they are seeking for is they are telling you that this is what you said in the Justice Abdullahi case.
Right.
And applying it to the proceedings on that 29th day of March in Parliament, what happened is in contradiction to what you have said in the Justice Abdullahi case, and therefore a nullity. So the Supreme Court would first have to confirm whether what the minority is saying they said in the Justice Abdullahi case is actually what they said. So that if the Supreme Court confirms that this is what we said in the Justice Abdullahi case, and this is how it should be interpreted and applied, then it means that we are determining whether or not the quorum should be 138 or 139. You understand me?
Right.
As it were. Then if the Supreme Court makes that determination, I believe then now it becomes an issue of fact. Whether there were 136 members or there were 138 members. And
Right.
that the Supreme Court may have to call evidence to determine the number of persons that were in Parliament on that day.
Right.
I do not think that this is a situation where the Supreme Court may grant some of the reliefs and may not grant others, because if you read it carefully, they are all intertwined. So that most of the reliefs are based on one. So like it's foundational. So okay, you agree with this, then these are the consequences of what you have agreed on. So that once the Supreme Court confirms that okay, the premise on which your action is based, i.e., what we said in the Justice Abdullahi case is actually what we said, then it becomes issues of fact to determine whether or not the numbers in Parliament met that quorum that we had laid down in the Justice Abdullahi case. And I think that it will become an interesting situation.
It will indeed be an interesting situation. And this in itself is quite a quagmire that the court finds itself in, because, I mean, it's tricky. We've had the Speaker of Parliament come out to back the decision that he took on the day to allow the vote to go on and all of that. We've also heard from, well, in fact, not hearing from, the President expressed his gratitude to Parliament for having passed the bill into law, with he himself giving his assent to it to make it law firmly. But by doing so, some feel that with the statement or the comments by the Right Honourable Speaker of Parliament, and also buttressed by the signing into law of the bill by Mr. President, they are in a way stifling the possibility of the apex court to do otherwise or state otherwise. So clarify for us, the mere signing of this into law, does it have that effect? Could it compromise in any way the Supreme Court's decision? Let's start from there.
Absolutely not.
Absolutely not.
Absolutely not. The Supreme Court can declare an act of parliament a nullity as being in contravention with the provisions of the 1992 Constitution. And that their jurisdiction has been invoked presently by the action of the three members of the minority. Under Article 2 and under Article 131, I believe, they didn't state B, but I believe particularly B, of the 1992 Constitution. So the fact that the Speaker of Parliament had said what he did, he thinks is right. The fact that the President has assented the bill and made it law does not in any way undermine, it doesn't render the suit before the Supreme Court moot. It doesn't undermine the jurisdiction of the Supreme Court to declare what the proceedings that occurred in Parliament as a nullity. In law, we say that you cannot put something on nothing and expect it to stand. And so once the foundation of that act of assenting to that bail, which is the proceedings on that day, is declared a nullity by the Supreme Court, every other thing that is based on that 29th March automatically will fall because the foundation has been swept off. And so the Supreme Court can still proceed and then declare or grant the relief sought for by those who have filed the present action. And then by extension, whatever act or the fact that the president has assented to that bail would also be declared a nullity. My only challenge legally is if the Ministry of Finance or the executive, as it were, asks the GRA to start implementing the E-Levy from today.
Well, they've spoken about the 1st of May, so that wouldn't really come into question.
No, I mean the 1st of May.
Right.
And they start collecting monies. And the Supreme Court delivers the verdict or the decision and says that it was a nullity. Right. What happens to the monies that have been collected?
But is that not even before you continue with that? So that is even more reason for the apex court to approach this swiftly, isn't it? Because if it gets into that, then it could also imply, I mean, once people start, transacting and the levy is, taken out of, the component is taken, this could basically mean there's no turning back, right?
Yes, yes, it could mean that there's no turning back in terms of those who would have paid the levies. Because at the time they paid, it was law. So you cannot, do that. But the Supreme Court, apart from election petitions, there's no law that states that when an action is filed, it should be heard within a particular time. The Supreme Court may, because the Chief Justice even may or has the right to ask the bench to sit even during the holidays. Right. The court will go on the Easter break, I think from the 15th, and will resume from the 25th or so. And so unless the Chief Justice deems it very fit, may decide to ask that this case be fast-tracked so that the times for filing responses and whatever and sitting and legal argument will be done before the 1st of May. That is completely a prerogative of the Chief Justice. And if the minority, those that filed the action, thinks that it's in the best interest of justice and the country to do that, I believe that they know what to do to plead with the Supreme Court and the Attorney General, the Chief Justice and the Attorney General, to have this matter fast-tracked. But it does not in any way affect the jurisdiction of the Supreme Court to go back and say that what you have done, everything, including signing it into law, the proceedings of that 29th, is a nullity because it contradicts the provisions of Article 104. And so every single structure that has been built on that faulty foundation should be pulled down. They've always done that in the past, and nothing stops them from doing it now.
So the law as we know it is practically never retrospective. In other words, you cannot institute a law today and fault me for what I did yesterday. So in this instance, it would mean that if it went into effect, came into force on the 1st of May, and some people had made payments, and later the court quashes that decision, it means they would have lost that money. That is it. There will be no avenue of seeking redress because, like you said, it was law at the time. Just to clarify.
I do not see any legal avenue available to them because at the time they made the payment, it was law.
Right.
And until it was declared a nullity by the Supreme Court, it could be enforced. Okay. So I do not see how those people would benefit from the decision of the Supreme Court and go back to Parliament unless the Supreme Court specifically adds as one of those reliefs that any person who has paid money +1 to that should be refunded. But I do not see the Supreme Court doing that. I do not see the Supreme Court.
Finally, what do you think the consequences could be because look, now we've gone through the entire process and we're in the balance. Has the E-Levy been passed? Has it not? It's been signed by, given executive backing by the president, and now we call it a law. But what does all of this mean? What could be the consequences if the Supreme Court strikes down what happened on the floor of Parliament when the bill was passed? What happens? I mean, what could be the consequences on the legislative body itself, on the executive, and the wider bit about securing funding for our country? I just want you to, what could be the likely consequences? Because it would create quite a thorny situation, wouldn't it?
Well, I believe it will. But there will be the social aspect, there will be the political aspect, and there will be the legal aspect. I would want to stick to the legal aspect, where I think that it will not stop the majority from reintroducing the bill in Parliament.
Right.
The majority would always have the chance to reintroduce it and then do what they can do to make sure that at this time, they would have the necessary quorum to carry on the business and then conduct the vote. And so that would be it. But in terms of the court, the social, the financial impact, I would want to leave it to those who are better placed. I mean, they've said that if we don't pass the bill or we don't start collecting those monies, there'll be a large hole in our revenue. And the consequences of that are there for everybody to see. I do not think that any Ghanaian wants Ghana to go into that situation where we will be financially desperate. But I believe that a lot of people are also of the position that there are better means or better ways to raise the necessary funds. But that is a political decision. And I believe that those that are paid by our tax money to take those decisions on our behalf or to think through those processes would be better placed. If the majority of the Ghanaians think that they've not thought through the processes in a way that benefits all of us, we would have an option to let our voices or our dissent be heard come election day.
Well, Lawyer Bobby Banton, thank you so much for engaging us and giving us insight. After the Supreme Court delivers its ruling, we'll come back to you and see what you make of it. But we're grateful for your time, sir. All right, so that was Bobby Banton joining us there. When we return, we'll continue with some talk about the E-Levy, but we're going to be focusing on the State of the Nation address and, economically speaking, what is in there for all of us as a country. We're going to be engaging GUTA, we're going to engage the Peasant Farmers Association, among others, to gauge how they feel about what Mr. President said and what the impact is going to be on all of us. All of that after the break. Stay.